high honor that he is taking us on and dedicating the Robert H. Jackson Center. The Chief Justice of the United States, William H. Rehnquist.
Thank you. It's a great honor to be here. Thank you, Professor Barrett, for the kind introduction. I'm delighted to be here for the dedication of the Jackson Center. I served as one of his law clerks for a year and a half, and it was one of the most rewarding experiences of my life. Justice Jackson served as an Associate Justice of the Supreme Court from 1941 until his death in 1954. And during these 13 years, he made significant contributions to the court's jurisprudence. But unlike any of his colleagues, before or since, he was a principal architect of the Nuremberg war crimes trials held immediately after World War II. He described this effort as the supremely interesting and important work of his life. So a good portion of my remarks will be devoted to that aspect of his career. He was born, of course, in 1892, grew up here in the Jamestown area. He was admitted to the New York bar without having a law degree and developed a very successful law practice here. He was also active in the state Democratic Party and as a result became a friend of Franklin D. Roosevelt. After Roosevelt became president in 1933, he brought Jackson to Washington as general counsel to what was then the Bureau of Internal Revenue. Jackson rose rapidly in the executive hierarchy, serving as Assistant Attorney General in the Antitrust Division, Solicitor General, finally Attorney General. Justice Louis D. Brandeis expressed the view that Jackson should be Solicitor General for life, a high compliment from one who did not bestow compliments casually. When Roosevelt elevated Harlan Stone to the Chief Justice in 1941, he appointed Jackson as Associate Justice. Franklin Roosevelt died at Warm Springs, Georgia on April 12, 1945. He was succeeded by his vice president, Harry S. Truman. The Allies in Europe were sweeping to victory. VE Day was less than a month away. In late April, Truman asked Justice Jackson to take on the job of Chief U.S. Prosecutor before an international tribunal to try high German officials accused of war crimes. Within days, Jackson wrote to the president accepting the position, and by an executive order dated May 2nd, Truman appointed Jackson as chief prosecutor. In accepting this job, Jackson took on an enormous responsibility, not just as an advocate for the tribunal, but also as a de facto ambassador and an administrator. He later said that it was the first case I've ever tried when I had to first persuade others that a court should be established, help negotiate its establishment, and when that was done, not only prepare my case, but find myself a courtroom in which to try it. There had never been such a tribunal before. Of the 22 defendants, 12 were sentenced to hang, 3 to life imprisonment, 4 to terms ranging from 10 to 20 years, and 3 were acquitted. Jackson understandably regarded his participation in the Nuremberg trials as the crowning achievement of his career. Speaking to the New York State Bar Association in 1947, Jackson said that his Nuremberg role, quote, was the supremely interesting and important work of my life, and an experience which would be unique in the life of any lawyer. When I served as Justice Jackson's law clerk, it was 6 or 7 years after the Nuremberg trials, and they had been controversial at the time. So I studiously refrained from asking him anything about them. But one day, a friend of mine who I'd known at graduate school was down visiting me. He was very interested in international relations. So he came into my little office adjacent to Justice Jackson's, and we were talking. I just wanted to show him the office. And Justice Jackson walked in, and I introduced him. And then he said to Justice Jackson, what I'd never dared say, how do you justify the Nuremberg trials? Here was this guy, 25 years old. Well, Justice Jackson, far from being offended, went into a 10 or 15-minute eloquent justification of the Nuremberg trials. He actually welcomed the question, and I was pleased there to be in the audience just to hear it. Jackson returned to the court for the term that began in October 1946 and served until his death in October 1954. But what strikes me most about his court work was his masterful use of the English language. What makes this mastery truly impressive is the fact that Jackson had no formal education beyond high school, except a year at the Albany Law School. And certainly law schools are not places known for their teachers of great English prose style. He wrote the opinion of the court in West Virginia State Board of Education versus Barnett in 1943, in which the court decided that even the need to stimulate wartime patriotism did not trump the First Amendment rights of school children to refuse to salute the American flag because of their religious beliefs. In his opinion for the court, he wrote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections." The Steele seizure case, which came in 1953 and ran its brief course from beginning to end during my first months as a law clerk, was one which was intensely covered by the media in the spring of 1952. And of course, all the law clerks, as you can imagine, were just dying to find out how it came out. You know, the court held its conferences on Saturday in those days, and I remember George Niebank, who was from Buffalo, and I were the clerks at that time. We were anxiously waiting for Justice Jackson to come back, and so he said, "Come on in the office," and he said, turned and said, "Well, boys, the president got beat." It is Jackson's, I believe, which has best stood the test of time. Presidential power, he said, is divided into three kinds. The first was where the president acted pursuant to congressional delegation of authority. Here, presidential power was at its apex. The president had not only the power of the executive, but the power of the legislature behind him. And only if the act was beyond the authority of the federal government itself would a presidential act be struck down. The second case was where the president acts in the absence of any congressional expression on the subject, one way or the other. There he has the power of the executive, but not that of Congress behind him. The third is presidential power at its nadir, when the president takes measures to deal with a situation in a particular way where Congress has said that it should be dealt with in a different way. This, in Jackson's view, was the situation in the Steele seizure case, and that was why he joined in ruling the seizure unconstitutional. Although no one else on the court joined Jackson's opinion at the time, the court has since cited it as governing law. In a poll of legal academics conducted some 30 years ago, Justice Jackson was rated as a near great among the 100 justices who had then served. It is worth noting that all but one of the 12 justices raised as great had either served considerably longer on the court than Jackson or had held the office of Chief Justice. Surely Jamestown and Chautauqua County can be proud of the career of their native son on both the national and the international scene. Thank you.